We've got a great speaker here at NHMR to speak to us about a NAR legal update on the COVID legalities. That's the name of the talk. The slide deck, as well as this webinar, which is being recorded, will be available to all of our membership afterwards. There will be a question format. Deanne has offered to pause during certain segments kind of throughout the presentation so that the questions are relevant to what she just spoke about. We ask that for any live participants that you ask your questions in the chat box function. I will be monitoring those as we go through. If you have a question, just type it in. And we will get to those at each pause. If you don't get to it, that's fine. We will also have a bit of Q&A at the end. So feel free to take some notes and save some questions. We've blocked out about an hour. We'll see how long it takes. The presentation should be about 30 to 40 minutes, somewhere in that range, and then a little bit more with the Q&A. And with that said, I'll give a brief bio of who our speaker is and then hand it off. Deanne Rymarowicz is NAR Associate Counsel. Before joining NAR, she was General Counsel for the Greater Las Vegas Association of Realtors. That was for 8 years. She has also served as counsel for the Nevada Real Estate Division. She has an extensive background in transactional administrative law, focusing on corporate, insurance, and mining law. So without further ado, Deanne Rymarowicz.
Thank you so much, Jed, and thank you to NHMR for inviting NAR to participate in today's webinar. It's great with the virtual format. We can just get out more with the members, and I'm delighted to be able to share this information with you today. We're going to talk about several important issues facing realtors all over the country and the real estate industry in general. But first, of course, as an attorney, we have just a general disclaimer that we're providing general guidance, and everyone is reminded to consult with your local legal counsel, public health information, including the CDC, as well as Connecticut health agencies, and all applicable executive orders and agency guidance, as required policies and practices can vary based on state and local law and may change. So we're recording this on June the 18th, and who knows, some of this might be outdated in a week, a month, sometimes even a day, because even though we feel like we're close to coming out of this pandemic, you never know. I think that's been the lesson from the last 3 months is you just don't know. And pivoting, adapting, changing, the real estate professionals, you have been incredible in adapting to a very unique and incredible circumstance. And that skill is going to serve you very well as we continue to reopen, readjust, and come into this new normal, as everyone keeps calling it. So today we're going to talk about 3 main hot topic issues. First, how do you conduct in-person showings with all of the guidance and restrictions that are out there from the various health agencies and even at the brokerage level? We'll talk about complying with the Fair Housing Act. And here in Connecticut, your state was really on the forefront of looking at fair housing issues with regard to COVID-19 pretty much at the beginning of this. Like it's, you know, as I said, you were on the forefront. So we'll talk about some of those issues as they've evolved over the last several months. And then finally, you are an essential service in Connecticut. So you've been able to do your job, but some offices may still be in that reopening phase. And how do you adapt? What do you need to have in place as you reopen to the agents and the public? So with that, we're going to jump right into it. Oh, and as Jed mentioned, I'll pause between those sections. So if you have a question and it comes to you while I'm speaking, just pop it into the chat. Jed will be monitoring those, and I'll pause at the end of each section to ask for questions, but it's okay to ask them at the end as well. Now, as we go through today's materials, you're going to see these 4 guiding principles sort of woven into everything that we're talking about. First is compliance. It is so important to continue to follow CDC recommendations and adhere to state and local requirements. So in some states where we speak, the locale, the actual individual area may have their own advice. So if you're practicing in multiple jurisdictions across county lines or in different cities, be sure to check the local restrictions and guidance as well as your state. Second is to communicate. Never has it been more important to be in touch with your clients. People want to know what you're doing to help keep them safe, how you're adapting your practice, how you're changing your protocols, and what they can expect. Anytime that we can tell people in advance what to expect, that will help everything go more smoothly and kind of help calm people down. Again, it feels like we're reaching the end of this, but let's not get complacent and still communicate. Next, of course, your contracts. Now, your state association has several fantastic forms, a COVID-19 addendum, as well as a sight unseen form, and keeping your contracts and your forms as they're agile and they can address specific situations. And then the fourth guiding principle is to continue. Don't take your foot off the gas. Continue those best practices like virtual meetings, encouraging, fewer in-person contacts, and using electronic solutions like electronic signatures and virtual tours. So we're continuing with that phase. Even though, we're also reopening, we're still encouraging limiting to essential functions and limiting those in-person interactions. And when there's no specific guidance, what do? So you may come up against something that you can't find an answer for on the Connecticut State website or the NAR website or the CDC website. What do? Keep these three things in mind always. Can you demonstrate care for the well-being of others? Health and safety is your first priority. Limiting those in-person activities to the essentials. That has been a thread as I reviewed all of the documents that Connecticut Realtors has produced, as well as your state agencies. It's limiting things to the essentials. And then mitigating the inherent risks of COVID-19. This really is a risk management webinar. And part of that is knowing what the risks are, how the exposure to that risk might come up in your day-to-day business, and then finding ways to mitigate those risks. So really, these three things are also woven into all of the guidance that has been put out on the national, state, and association level. And you'll see as we go through the materials that these things are absolutely at the forefront. Now, a couple of weeks ago, NAR commissioned some consumer surveys. There's actually a series of 5 surveys. These are the results from the most recent, and the survey company asking some different questions. This survey was actually prepared by NAR Research, and we asked brokers all over the country, how are you changing your real estate practices to adopt to federal, state, and or local regulations and guidance? And I think this is really interesting to see how other brokers around the country are responding and see if any of this resonates with you. Social distancing, absolutely number 1. No open houses. Open houses are still discouraged. We'll talk about some safe ways to reincorporate or continue in-person showings, but open houses are still off the table. Showing by appointment. This is so important to avoid overlapping, buyer groups or multiple buyers looking at a home at the same time. I think this is true even for vacant properties. Remember those days when you would drive around with clients in your car and, oh, there's a listing that we haven't seen. You look it up on your phone, it's vacant, maybe shoot the listing agent a text, use your key to get in. Those days are gone. Like, we really need to create those appointments so that we can organize and keep everybody safe. Again, remember, number 1 is safety. Sanitation for in-person showings. Our research has revealed that clients really want to know what's been done in the house, what you're doing, and what those protocols are. And over half of brokers are making those changes to their practices and providing masks and gloves for clients. A little less than half are doing that. So you can see how, again, how brokers around the country are changing. Only 5% have made no changes to their business. So really the extra supermajority of brokers around the country are adapting and changing. And as I mentioned in the beginning, you are known for this, right? You are known for riding the waves of change and making the most of it. And I have no doubt that you will continue to do that as the pandemic subsides and we emerge into the new normal. Now, since we are talking about risk management, this was an interesting question about lawsuits. Do you have any concerns about lawsuits against you or your firm related to COVID-19 around any of the following? Showing client homes was the #1 concern when it comes to litigation. Now, 60% of respondents had no concerns, which is really good. But of those who had concerns, showing those in-person listings is absolutely the #1 concern. So we'll talk about ways to help mitigate those risks. Now, I want to point out that the survey kind of broke down by region as well. And your neighbors in New Jersey and New York and close by in Pennsylvania, they are the most concerned about potential lawsuits. So your region, your kind of general area is on higher alert. So that's why the protocols and safety guidance that we'll talk about today are very important to help quell that, sense of litigation among buyers and even sellers. Okay, let's jump into showing guidance and showing in properties in person. Now, as you know, you have been an essential service since the beginning of the pandemic, and showings may not have abated much in your area, although I understand that virtual options have been heavily relied upon in your area. Now, when it comes to resuming or continuing in-person showings, masks are absolutely required. They're required by the state. There are very limited exceptions, and this is an enforceable requirement. The Connecticut Department of Economic and Community Development has this requirement for real estate licensees, prospective buyers, appraisers, and inspectors when they're going into a home to wear a mask or cloth material that covers the nose and mouth. Now, those exceptions are people for whom they face additional health risks, or perhaps young children under the age of 2, or a child on whom the parent or guardian can't place a mask. And this also includes occupants of the residence. So let's say the seller is going to stay in the home while the home inspector's there. The occupant also needs to wear that face covering when another professional service is in the home. Now, as I mentioned, this is enforceable. Real estate agents are actually required to require their buyers to have a mask. So it might be a good idea if you can get a few extra masks. The Realtor store at realtor.realtor, I'll find that URL for you. We actually have masks in stock ready to ship. If you're having trouble finding those, NAR has you covered through the Realtor team store. But you are required to make sure that your buyer has a mask. So we'll talk about ways to make sure that that happens in terms of communicating your new protocols. And this is interesting. One of the consumer surveys that our outside survey company did in late May showed that consumers actually expect you to know and enforce the protocols. So it's actually a consumer expectation as well as a government requirement. Now, your government guidance also indicates that entry to the property will be denied to anyone who refuses to comply. And also gloves are recommended. They are not required, but they are definitely recommended. All right, let's continue on. with some more showing guidance. So NAR has produced a showing guidance document. I'll give you the URL at the end of this presentation where you can find every one of the NAR guidance documents that I'll speak to. And the NAR guidance document supplements the guidance that's been produced by your state. And the NAR document follows the CDC guidelines. And we looked at different stages of in-person showings and literally sort of did a virtual tour. You know, we kind of brainstormed, okay, now what? You know, you make an appointment and then what? And then what? And then what? And literally put ourselves in the position of the buyer or the agent and walked, you know, simulated walking through a listing to go, okay, you know, where's the potential exposure to a risk here and how can we craft a protocol or a strategy to mitigate that risk? So that's where NAR's guidance sort of came from. So we break it down into stages before, during, and after the showing. So before the showing, it's a great idea. Remember, we talked in the beginning about continuing to use those virtual options and limiting in-person interactions to the essentials. It's a good idea to maybe narrow down the number of properties that you're going to look at in person with your buyers by using those virtual options. Set an appointment with the listing agent so that the listing agent can schedule appropriately so that there's, reduce the overlap, maybe allow for cleaning in between showings. So do make those appointments with the listing agent. And while you're making that appointment, talk to the listing agent about any special requirements that the seller might have. So the seller may require everyone to wear gloves or wear booties. So be mindful of those requests and requirements from the seller and be sure to take steps to comply with those. Ask the seller to open the cabinets, open the closets, turn on the light switches. Anything that you think a buyer might touch, have the seller do that. So the seller is comfortable with who's touching their stuff, right? And ask the buyer to select who will be present at the showing. This is really important for fair housing considerations that we'll talk about in just a moment. I understand that Connecticut limits the number of people in the premises at any time to 5, and that would include the agent. And if the seller were staying home during the showing, that would include the seller. So be sure that you know who is going to be there. Take a step back from dictating who on the buyer side can be there. Advise the seller, this is the max, this is what I will be enforcing, and allow the buyer to choose who will be there. Some people say just limit it to the decision makers. Don't bring the whole entourage of their decorator and their cousin who's a contractor, but limit it to the true decision makers. But let the buyer make that ultimate decision. And then before the showing, ask if the buyer or anyone who is viewing has any symptoms of COVID-19 or has had any exposure to COVID-19. We'll talk more about how to do that when we talk about some fair housing considerations in the next section. Now, during the showing, meet the clients at the property. Again, gone are the days of driving your clients everywhere, right? So meet your clients at the property, ask them to remain in their car and, not get out and start looking through windows and things of that nature or going up to the door themselves. So have them stay in their car, greet them, but avoid shaking hands. Bring hand sanitizer and ask them to use it so that they're, cleaning their hands before they enter the seller's home. If they haven't brought a mask, and a mask is required, of course, as we discussed earlier, then have a couple of extra masks in your car to offer to the buyer so that they can comply with that requirement. Once you're in the home, try to maintain a social distance, that physical distance of 6 feet, really at all times. And avoid sharing pens, tablets, or phones. Oh, one other thing. You know how you sometimes would print out the listing and bring a copy to your client? Try to make that electronic and maybe email it to them ahead of time and allow them to pull it up on their phone. Let them take their own notes with their own pen or their own tablet or on their own phone and avoid sharing those back and forth between you and your client. And of course, make sure that neither you nor the buyer are touching any surfaces, especially if you're not wearing gloves. Avoid using the bathrooms. And if there's something that needs to be opened, make sure that you are using a gloved hand to do that, and have some sanitizing wipes with you to be sure to clean that and disinfect it after you use whatever surface that is. All right, now afterwards, you go out to the front yard or the garage and you stand there and talk and chat about the home. Try to avoid that. If you do, make sure it's in a well-ventilated area, either outside, and make sure you're maintaining that 6-foot distance, or better yet, arrange to follow up by phone or email after viewing the property. Again, any paperwork that needs to be followed up with, make that electronic and avoid that paper interaction person to person. Any surfaces that were touched, be sure to wipe those down with a sanitizing wipe or cleaning materials. Maybe the seller has left out cleaning materials that they would like you to use. And ask the seller, this is especially true for listing agents, request that the seller, remind the seller that they would want to clean and disinfect those surfaces that could have been touched. If you're using a lockbox and the keys in the lockbox, make sure you're wiping down both the key and the lockbox, the keypad, if there is one. Wipe those things down with a sanitizing wipe. And then this is really important. Once you get back into your car, you can use hand sanitizer, take off your mask, and then write a log of who is at the showing, the date, the time, who is there, as well as their contact information. What we're doing is we're creating a contact log should anyone exhibit symptoms of COVID-19. That will help immensely when tracing, doing a contact tracing for that individual. So make sure that you're creating that log. It shouldn't take too long, but it's a really important extra step to take, again, as we're in this new era. So I will take a pause, have some water, and ask Jed if there are any questions about showing guidance or the introductory material.
Great. Thanks, Deanne. I don't see any questions yet, but that's not atypical. If any of our members tuning in live do have questions on that first section, please go ahead and type them into the chat. And I will ask a couple just to give us some time and see if anyone else has some questions. But one of them was, you mentioned that masks in Connecticut are required. And you said it's enforceable. I think you referenced our DECD, the Department of Economic and Community Development. And that also we're required to make sure our clients, our buyers at least, are wearing them. And I'm wondering, do we know enforceable how? Is it, is it a complaint through a typical licensure avenue? And do we know, or have they said what the penalties are? Do we know anything about that?
I haven't seen anything about penalties. So the advice from the state does say that entry to the property should be denied for anyone who refuses to comply. So if there is, but there's also the caveat, if someone says, I have a medical condition that doesn't allow me to use a mask, you cannot ask what that medical condition is. You can't ask for, proof of a doctor's note that they can't wear a mask. But the guidance does say that entry should be denied for anyone who refuses to comply. So perhaps you use a virtual tour, you FaceTime, you make a recording, or you have them on a Zoom call. They cannot or refuse to wear a face covering. I also know that the state has a hotline set up, a 211 hotline to report potential violations. So that may be an option as well, particularly if it's an agent who is refusing to comply. I would certainly contact the broker and let the broker know if licensee is refusing to comply, because, this is for everyone's benefit and everyone's health and safety. Although you're right, there aren't specific penalties that I've seen for refusal to wear a mask.
Okay. And kind of a related question, I'm sure I could recite our NAR Code of Ethics by heart. But that said, I am wondering, does any of it apply, or has anyone come through it to see if it applies in this situation where there could be an ethics issue that comes up for a realtor who's not complying with the CDC recommendations? Have we looked into that, or do we know anything about that?
That is a very, very good question. And I haven't seen anything. There may have been a blog post, but it was back in the very beginning. And the thing is, I think guidance and opinions have sort of evolved as we've learned more about the virus, as we've learned more about recommendations from the CDC. So I wouldn't be surprised to see, especially if it was a pattern of behavior, that there would be an attempt to file an ethics complaint, but it would be up to the association's grievance committee to really review that. And I think that's an excellent point that I'm going to take to our professional standards policy folks and see if they can put something out about that, because I think it's a great point that you're touching on. Okay.
We did have a question come in. This is almost it looks like a question for a group, but since you've been speaking to other groups, maybe you've run into this. Realtors who are providing masks, gloves, booties, sanitizers, have there been issues with those things disappearing from the property? And I'm guessing particularly in times when they were hard to come by, that might have been an issue. But
that's a really interesting question. I have not heard of that. But as you say, it wouldn't necessarily surprise me, particularly when those items were not as widely available. So I think as the buyer's agent, you would want to have a small supply in your car so that you're not relying on those things being available at the property. You be the responsible one, bring the sanitizing wipes if you can find them, the gloves, the masks, the hand sanitizer, bring those with you, and don't rely on the seller or the seller's agent to provide those items.
Sure, I think that's great. And I'll just chime in that I've had, rather than leave a box of 100 gloves out, you can leave, there shouldn't be more than 5. You could leave a set out, or have a seller leave some out and kind of keep pulling from it, so you don't need to leave the whole supply out. We do have an interesting question here, distinction about when you require that a buyer show a pre-qualification letter before showing in person. Can you essentially raise the bar a little bit higher and ask for it to be a pre-approval? So I guess the distinction here is that they have to, have provided documents to their lender and show an even greater buying capacity.
Right. So I have heard of that as being an option, either a pre-qualification or approval for, again, narrowing those choices, eliminating the looky-loos who just want to see inside a property, and limiting those in-person showings to serious buyers who are qualified for that property. However, the caveat there, of course, that could bump up into fair housing issues. So if you are going to require either a pre-approval or a pre-qualification, make sure you're doing it with every customer, every client, every potential buyer, every single time. Otherwise, that is a classic, and it came up in Long Island, in the Newsday investigation in Long Island. That was one of the big issues, was asking some people for pre-qual and other people not. So make sure, if you are using that as a tool to narrow down in-person showings, that you're asking everyone.
Yes, consistency is key across the board.
Absolutely.
The next question actually, I think, may also fall into your next fair housing topic. So feel free to punt it if you're going to cover it. But someone is essentially asking, and I'm going to preface it with what I assume the preface here is that, children in a home are a little bit harder to control, especially younger children. But at the same time, is there any legal or fair housing issue with restricting children on showings or in the home?
That is an excellent segue to my next section, and I do talk about that. So I am going to for about 2 minutes.
I think we'll just about get to that then. I don't have any other questions here. I have one more that came up for myself that I just want to remove off this section. And it was in your survey, you had 34% concerned about a lawsuit over showing client homes. And I'm just wondering whether, I know all sorts of brokerages have been kind of on their own, including various clauses or language in listing agreements and elsewhere. But I'm wondering if there's any standardization of a recommendation for some sort of hold harmless in a listing now related to COVID-19 risk, whatever that may be.
Right. Well, and this question has come up all over the country. Brokers really want to know if a hold harmless agreement is a good thing. And here's what NAR has said about that issue. So the thing about COVID-19 is it is so pervasive. It is so contagious, and it has been publicized, for lack of a better word. It has been publicized probably more than any other issue in the history of the planet. If you don't know that COVID-19 exists, I don't know,
Right.
live. But, so, it's an open and obvious risk. And because of that, it's also very difficult to prove where it was contracted, where or how it was contracted. So proving that a buyer got COVID-19 from visiting a home, or that a seller contracted COVID-19 because someone came through and touched their toaster or their closet doorknob, would be extraordinarily difficult. That said, some brokerages have instituted hold harmless agreements, really in an effort to put the buyers on notice that, hey, there are inherent risks. You are assuming those risks. And it may give a measure of comfort to those brokers. And I would, if you are going to use a hold harmless agreement, be sure to contact your legal counsel and make sure that it meets your state law requirements. But if you do use a hold harmless agreement, it's more for noticing the buyer, again, perhaps a measure of comfort for you. And the problem is, it doesn't take a lot to file a lawsuit. So, a buyer can still make that claim, and the brokerage, the agent, the broker would, still have to, move to dismiss it. They can attach that hold harmless or whatever strategy their defense counsel uses, but it doesn't take a lot to file a lawsuit. And that hold harmless agreement is at least some measure, as I said, to show the judge, look, the buyer knew about the risks. We haven't seen any resolution on any cases that have been filed. I'm not aware of any filed in the real estate industry on this issue. Certainly there have been other, workers in other industries who have filed lawsuits. We haven't really seen any resolution on those, although, avoiding known risks, if you can show that you're avoiding known risks, show those protocols that we're going to, all the showing guidance that we just talked about. You can prove that, you're instituting that across the board. That's going to go a long way to mitigating any risk if you were to be sued.
Great. And I think we're ready to move on. We have one last question here that's come in, and I think it's essentially all of these guidelines that we've discussed, we assume apply to commercial transactions and commercial practitioners as well, or is there any distinction or carve-outs or anything different there?
Thank you for reminding us that, commercial real estate is still alive and well as well. So yes, especially the state guidance really doesn't make a distinction on that issue. So certainly if you're showing properties in terms of especially commercial buildings and reopening commercial buildings, there may be actually heightened standards for commercial spaces, but for showing purposes, definitely the masks, sanitizing, make those appointments, clean those, if you do touch surfaces, clean those, that would apply across the board.
Okay, great. Thank you very much. That's it for panelist questions. So I'm going to hand it back over to Deanne, and if everyone can keep questions coming on the next section too, we'll get to that shortly. Thanks. Okay.
All right. Thanks, Jed. All right. Let's talk about fair housing guidance. Now, as I mentioned in the beginning, Connecticut really was the forerunner and was thinking about this issue before anyone else in the country. So you may have already learned all about this, but we will talk about children in just a minute. But the question on everyone's mind from the beginning of the pandemic was, is COVID-19 a disability for purposes of the Fair Housing Act? And this really is a new and novel question that ultimately will probably be decided by a court. But based on the information that we currently have available, because COVID-19 can have severe symptoms and can actually be lethal to some people, it may ultimately be interpreted as a disability for purposes of the Fair Housing Law. So while it hasn't been conclusively determined that COVID-19 or having symptoms or exposure to COVID-19 is a disability under the Fair Housing Act, it's advisable to treat individuals who have COVID-19 as being covered by federal disability protections. So, and that would also include state disability protections as well. So yes, for now, it hasn't been determined it's a disability, but it's the best recommended practice is to treat it as a disability. So here's the question. Can I disallow children at an in-person showing? The question from the participant just a few moments ago was talking about, children may be a little bit harder to control when they're visiting a property and certainly running around and this is my room and let's look at the backyard while the adults are, still looking at the kitchen. So can you restrict children from attending in-person showings? And the best guidance that we have is that imposing such restrictions, saying children are not allowed, is not a recommended best practice. The Fair Housing Act prohibits discrimination based on familial status, and restrictions on children and families with children may create legal exposure under the Fair Housing Act. So if you wish to place restrictions on entering the home due to COVID-19 related concerns, consider alternative restrictions instead, such as restricting the showings to purchasers of record, so the person who will be on the title, or as I mentioned earlier, Connecticut limits to 5 people in the house during the showing. And of course, adhere to CDC best practices to prevent exposure and the spread of COVID-19. I would also say, those restrictions could apply to the children. It is not clear that children must wear masks. The state guidance indicates children under 2 do not need to wear a mask. And other children, if the parent or guardian cannot place a mask on the child, may not be wearing masks. And, letting the parents know, look, we can't touch surfaces, and ensuring that they're instructing their children on that as well. But for you as the agent, that also means, maintaining and noticing if they are touching surfaces, if there are children at your showing, if they are touching surfaces, making sure that you're going back and wiping down those surfaces with a cleaner or a sanitizing wipe. Okay, the next question that we get a lot is, can I ask a client if he or she has been exposed to COVID-19? Whether they're experiencing symptoms, they have a positive diagnosis, or maybe there's someone in their household with COVID-19 and they've been exposed. Now, you may request that an individual self-disclose information about their COVID-19 status. Now, Connecticut guidance indicates that this should be done verbally. And asking people to self-disclose symptoms or known or potential exposures to the virus in order to allow you to take the necessary safety precautions. But again, because we're talking about fair housing, a uniform practice as to how this information is collected is advisable. So asking the same questions to every client. Now, here's a tip. Remember in the beginning, we talked about one of those guiding principles is communication. Well, remind buyers what your protocols are. Let them know, keep them informed. I mentioned when we were just before the presentation, I was speaking to Bernadette and Jeb kind of offline, and I said, salons in Illinois are finally allowed to open, and I'm getting my first pedicure since February tonight after work. And when I made the appointment, I got an immediate email saying, here's our protocols. When I got my reminder for my appointment, here's our protocols. And they told me exactly what to expect. think about doing something like that with your buyer clients, letting them know ahead of time. You're going to be required to wear a mask. Gloves are advisable. I'll ask you to use hand sanitizer. I will ask you questions regarding your symptoms of COVID-19 so that they're not surprised when they arrive to the property or you call them before showing and ask them this question. Again, communicate, communicate, communicate. Now, while such questions, a couple of caveats. While questions like this can allow you to take the necessary safety precautions, remember that not everyone who has COVID-19 are exhibiting symptoms. Many people are asymptomatic, so reasonable precautions should be taken regardless of whether you know if someone has the virus or is exhibiting symptoms. And always remember as well that while you can ask if they have symptoms of COVID-19 and asking them to self-disclose that, the sort of leeway to do that in this crisis because of COVID-19 does not extend to asking anyone a non-COVID-19 related health or medical question. So make sure, again, you're asking the same questions every time and keep it limited to COVID-19. And again, the Connecticut guidance is to do that verbally. So let's say someone does disclose that they have symptoms or they have COVID-19 or they've recently been exposed to COVID-19. Then what? Well, then it's time to talk about reasonable accommodations so that you can still provide those services, equal services to everyone regardless of their disability. When we talk about reasonable accommodation with regard to the Fair Housing Act and particularly COVID-19, the analysis has to evaluate whether the need to provide housing or services to individuals with COVID-19. Also, you need to protect the health of the people in the transaction. So we're kind of balancing. Yes, we need to provide equal services regardless of disability, but we need to keep people safe. The Fair Housing Act does not require that you jeopardize your own health or the health of other people in the transaction, but it does require that you look at reasonable accommodations. So when you're looking at reasonable accommodations, take into account the fact that the virus is highly contagious and that if contracted, it could result in illness or, again, even death for some people. And make the accommodation that is most suitable for your specific situation. So some examples of reasonable accommodations that we've seen could be virtual showings of properties, requiring that an individual send a proxy to view the property rather than viewing it themselves, or providing addendum options such as the sight unseen rider that your state association has, or a contingency that the contract is subject to a later in-person visit at a specified later date and time when the person is free of those COVID symptoms. However, to the extent that the accommodations for individuals who have COVID-19 virus still present a risk to an individual's health and safety, and if they do impose those risks or impose undue financial or administrative burdens or fundamentally alter your services, the Fair Housing Act does not require the provision of that accommodation. So to recap, you ask the question, the same question every time. A person self-discloses that they do have symptoms of COVID-19, then you're in a situation of looking for a reasonable accommodation specific to that circumstance, the risk, understanding that it is highly contagious. And if you cannot reach a reasonable accommodation, you do not have to provide services because, again, the Fair Housing Act does not require that you jeopardize your health or the health of others in the transaction. So I know that was a lot of stuff in a very short amount of time. So I'm going to pause again and let's take questions related to fair housing. Do we have any questions, Jed?
All right. I haven't seen any come in yet.
Okay.
So we'll give people a moment to gather their thoughts and chime in. I'm not sure I frankly had any myself. I think this is we all take fair housing every 2 years,
Right.
and this is fairly consistent, and I think that the types of reasonable accommodation that you suggested, sort of where the rubber meets the road here is what's most useful and most helpful, finding out, how do we do that? So the virtual showings, the showing by proxy, I think those things are all helpful. And then, of course, like you said, to the extent that something poses a real health risk, that is a carve out, and we probably just don't have, there's no case law on this yet. There's no precedent to look to, so you have to go by the general standards. But
right, and that's a really good point. I talk about going back to basics. Yes, this is a unique situation. This is a new, we're treating it as a disability for purposes of fair housing, but the basics are the same, right? So it like you say, you've been trained on this for years, so it's applying those same principles, those same guidelines. It's just a new situation.
Yes. So we have had a few come in. So let me get a few specifics out there before we leave for the last section. One asks, can you essentially require that parents hold the hands of children? That's the specific question. But I would guess to generalize it, you might also, can you require that everyone remain in one room, and you obviously you guys stay 6 feet apart, but some sort of level of coordination of a tour where people aren't roaming free through the house. Is that something that you could require? And again, the specific question is, can you require that the children hold hands or in some way be connected to the parent?
Again, we need to look at how do we apply this across the board. So I like the idea of everyone staying in the same room, because that's something that can be applied across the board, whether we're talking about a family with children or, a family bringing in, someone else to help assess the property. So it takes the familial status out of the equation. It takes the fact that it's a child out of the equation. Again, apply that consistently. And I think that is a good solution to, kind of avoid children running all over the house. I know I used to do that when I looked at houses with my parents. So it's pretty common. So I do like the idea, again, it can't be anything that you're only doing because they're a family, because then now it's getting into kind of a danger zone in terms of fair housing.
Sure. So here's another one about the requirement of a pre-qualification or pre-approval letter. And this agent has seen agents asking, I guess, of her buyers whether or not the buyer's job is good, is how it's phrased. I'm assuming here that what's leading to this is that many of us have seen buyers who were qualified either lose a job or if their income was not, a W-2 and they didn't lose a job, at least lost income. They're contractors or reliant somehow upon an economy that hasn't been working that well for a couple months. So in those instances, what's your recommendations, I guess, if you're working with a buyer, what's the limit of what the seller's agent should be asking you? And conversely, I guess, if you're asking the questions, what should you be doing beyond just asking for a pre-qual or pre-approval that might be acceptable?
I was actually going to try and pull up an email. One of the attorneys at Connecticut Realtors actually sent me an email the other day, and I'm not a Connecticut attorney, but I believe that there is, within the state fair housing law, there's an income, help me, I believe there is an income component to state fair housing law. So
source of income, yes.
Source of income, right.
Yeah, you can't discriminate based on source of income.
Right. So, the fact that they're asking, is your job secure? To me, that just raised an alarm bell that, are we now venturing into that source of income territory for purposes of state fair housing law? Because you don't know, they might have an enormous bank account and their job is, irrelevant. You just don't know. So I would rather defer to Connecticut Counsel about that particular issue, because you have that very unique provision in your state fair housing laws. when you start talking about, people's jobs. Again, going back to the qualification, I would hope, but I don't know how you require that, if a buyer's situation changes, that they would, go back and seek requalification. Like, here's my changed circumstance. Can I still be qualified? Again, you can't, I don't know how you enforce that. So just asking those, again, just be consistent, ask for the qualification or the pre-approval letter. If that is your practice, do it every time.
Right. That's great. And I think what came out there partly too, and I should flag that there are those two components to fair housing. There's the state as well as the Federal Fair Housing Act. So you need to be considering both in relation to COVID-19. This is another interesting question. Can you comment on the agents or whether they must follow the guidance that their brokers lay out? So this sort of runs into this classic territory of independent contractor. It's not an employer-employee relationship. So I'm reading into the question, but I guess I'm assuming that if a broker has protocols or requirements that extend perhaps beyond what CDC guidelines are or what state federal guidelines are those enforceable by a broker against their agent?
That's an excellent question. And it reminds me that in Connecticut, this is back on the mask slide, in Connecticut, employers are required to provide employees with masks. So if you're a broker and you have any employees on staff, you are required to provide them with masks. However, independent contractors, such as agents, have to provide their own PPE. I think if the broker wanted to, they could provide it, but they're not required under state law to make that provision. It would be up to them, up to the agent to provide their own masks. Now, that said, the broker has the ability to set protocols within the office. And in fact, now in this age of the pandemic, they are required to have certain protocols within the office, under state guidelines. So it's not just the broker saying, this is how we're doing things. Chances are they're saying that because there's, CDC recommendations, state agency recommendations, executive orders that are telling them that this is something that they need to do. And again, it really comes down to risk management and mitigating those known risks of COVID-19. And if you can show that you are taking appropriate steps, that really could help protect you down the line, should any sort of issues arise where someone's saying, blaming the broker because they contracted COVID-19. So it really is a risk management strategy for the broker.
Okay, great. I think that wraps up with this round of questions, so we could move on to the final section here.
Okay, sounds great. Another great segue into reopening. So as we've mentioned throughout today's presentation, you've been an essential service, able to conduct your business, but I understand a lot of brokerage, physical offices were closed to the public, and it's the broker's decision when to reopen those and how to reopen those. And Connecticut has really provided some good guidance on what's needed to reopen an office. I understand that as an essential service, you don't have to meet that self-certification qualification that other offices that opened in phase 1 starting May 20th had to do. However, I checked last night and there was about a dozen to 2 dozen real estate offices in your county that went ahead and did self-certify. You get that badge, you can put on your, post it on your front door, put it on your website. But again, I understand that is not required. And really, as we just discussed, having those protocols in place is a risk management best practice. But here's the good news. You don't have to reinvent the wheel on a lot of these protocols and policies that we're going to talk about. The state of Connecticut has really clear and concise reopening guidance. Honestly, it's one of the best documents I've seen. And I've looked at a lot of state reopening guidance, and this one is yours is pretty clear. I'll also talk about NAR's workplace reentry checklist that we produced last month. in response to reopening before a lot of states had guidance in place. And rely on the CDC. The CDC has some great, what I call printables. You can download posters, signs, little infographics on washing your hands. You don't have to recreate a lot of this stuff. It's already available out there to you. But of course, keep in mind that this is a fluid and dynamic situation, which requires flexibility and the ability to pivot on your part. And it's important to stay on top of updates from the state, the CDC, and OSHA, as well as the localities in which you have offices. Okay, let's talk about some basics from Connecticut. First and foremost is to have a plan. Literally put together a plan or a checklist. We're still encouraging remote work. At NAR, we're still teleworking through August 31st. But you, for your office, still encourage that telework or remote working. It's a good idea as you create the plan for your office to appoint a point person, someone who will be keeping track of all the protocols and appointing that individual that other agents or your staff members can go and talk to about the protocols if they have questions. Some ideas to limit capacity. I spoke with some brokers a few weeks ago that as they're reopening their offices, they're limiting it to 10 agents at a time. Connecticut also recommends that you stagger shifts and keep a log of who's in the office at what time. This goes back to the idea of contact tracing so that if anyone in the office does come down with COVID-19, you can know who was in the office, from what time, and who else was in the office to then, be able to identify those individuals and give them some heads up. Create a cleaning plan and a checklist for that. And of course, masks are required in the office. So as you come into the office, in any common areas and hallways, if your agents have individual offices or cubicles with partition walls, that's okay to remove their mask once they're in there. But as soon as they go out to, use the photocopier or use the restroom, they do have to put their mask on again when they leave their office. Preparing your workspace. Make sure that you've got that 6-foot social distance between workspaces. Look at your ventilation system. If you have a building manager, talk to them about the filters that you're using in your ventilation system and see if there's any capacity to increase outdoor air circulating. Now the medical expert guidance is, fresh air is good for you. So let's get more of that outdoor air into our buildings. Use social distance markers like tape on the floor. You've probably seen this in any retail establishment that you've been to recently, having X's or stickers on the floor 6 feet apart. Create partitions where you need it and use discrete work zones. And limit shared office equipment. So again, if you have one photocopier or one high-speed laser printer, limit the use of those and maintain sanitizing wipes next to that equipment. Post a sign, after you use this, please wipe down, the keypad, wipe down the paper trays. Any place where they would have touched needs to be cleaned. Impose hygiene standards within your workplace. Have hand sanitizers available. Encourage frequent hand washing. Make cleaning supplies available. That includes even at workstations. Again, posting a sign by the workstation. Be sure you're disinfecting your phone, your mouse, desk drawers, door handles into the office, and help your agents and your staff help you keep those germs out and keep it clean. Clean bathrooms frequently, particularly if you're using an outside company to help with your janitorial services. Make sure that they're maintaining a cleaning log of how often the bathrooms are cleaned. If you're instituting new protocols or you're cleaning more frequently, let your agents know that. Again, it will give them that sense of comfort to come back to the office. And follow CDC guidelines for cleaning and disinfecting. on the CDC's website, they actually have a list of approved cleaners, like cleansers, that you can get over the counter, like at any store, that have been proven to kill the coronavirus. So be sure you're using one of those approved cleaners for cleaning and disinfecting. And here's the important thing. All of these protocols are great, but there's another component. Connecticut requires this, NAR recommends this, and that is training. Training your agents on the new protocols. Create a training program. Have a Zoom meeting before people come back into the office. Explain what you've done. Explain what they'll see, the markers on the floor, the notices to wipe down the copier. Make sure that all your agents and employees are trained. Train them on the policies and protocols and on your plan that you have in place. And then Connecticut actually requires weekly refreshers. Now, if you're doing weekly office meetings with your office or a sales meeting every week, and you can continue those virtually, it's a great time to include that refresher. You know, remember, we have 6 foot distance, where we wash our hands frequently. We wipe down our workspaces at the beginning and end of the day. And whatever protocols that you have in place, make sure that you're reminding people of that. Again, this comes back to one of those guiding principles of safety first. And then signage. Start at your front door. Put a sign on the front door that says masks are required. If you have symptoms, we kindly ask that you don't come in. Explain what they'll see. You'll see, you know, plexiglass in front of the, you know, receptionist area, tape on the floor indicating social distance. Whatever protocols that you've put in place, alert people so that especially members of the public coming into your workspace, into your office, know what to expect. And then post reminders around the office about social distancing, cleaning protocols, washing your hands. Again, a lot of these are available already for you on the CDC website. You don't have to recreate these. And then have some policies in place. Keep up that, as I mentioned, remote work, encourage remote work, encourage agents and your staff members that if they're feeling sick, if they have symptoms, to stay home. Ask your employees to self-monitor and self-report symptoms. Have a plan in place if you do have a positive case of either an agent or a staff member or a client who has a positive case of COVID-19, and have that test and trace. Remember those logs we created after you did a showing and you're having a log of people who are in the office? That's going to be very helpful with the test and trace. And then the last thing I want to talk about is NAR's sample preparedness plan. Again, you don't have to reinvent the wheel on this one. We've got guidance for you in all of these situations. If an agent has a confirmed case, if an agent has direct contact with a confirmed case, if an agent was traveling and returns from an area and is exhibiting signs of illness, if an agent's seller or if an agent's buyer has a confirmed case. The sample preparedness plan, I'll give you the URL in just a moment. Our sample preparedness plan tells you step by step what to do in that situation. Use that in conjunction with Connecticut's testing and tracing protocols, and you will have a solid plan in place should someone report an instance of COVID-19. The key here, though, is protecting the identity of the individual. So it's not disclosing the name of the individual, but you may have been in contact with someone who has reported having symptoms of COVID-19, and advising them whatever the health guidelines are to be tested or to self-isolate for that 14-day period that we're also familiar with. So all of NAR's resources are available to you at nar.realtor/coronavirus. This is our landing page for all things coronavirus that NAR has produced, including that sample preparedness plan that I just talked about, that you are able to download and adapt for your particular brokerage office. So with that, I will ask Jed if we have any more questions on that last section about reopening guidance.
Sure. So here we go. Last chance, everyone. If you have some questions on that section, we don't have any in yet. And I don't think I have any myself. I think that was just a great set of best practices to go by. I guess I am curious. Let me ask a couple questions. I will dig into the comment that Connecticut requires weekly refreshers.
Yes.
Is there any requirement on what format that need be in? I mean, can that just be part of an office email? Does it need to be a part of a meeting? Is there any requirement that broker make sure it gets to someone or is opened or anything like that? Is there any more detail on what's required there?
I am not aware of any additional detail on that. I'm going to try and pull it up right now since we're talking about it.
Okay.
They have a really, let's see, I know they required training. All it says is there shall also be weekly refreshers on policies. Mm-hmm. So I think it's really open to you. You could do it via Zoom. I like the email idea, like in a weekly email blast. I just thought a lot of brokerages already have that kind of weekly meeting built in. So, it's something that would be really easy to incorporate into something that you already have scheduled.
Sure, makes sense. And I also just want to say I appreciate, and I hope everybody visits that link that Bernadette just reposted, and that was at the end of your slide deck here, the NAR.realtor coronavirus, because I think a lot of these issues are going to be ones that maybe any given one of us will not run into. And yet I'm sure that as a group, we'll all run into one of these issues at some point. So having kind of those protocols already in place, a quick reference for when that does come up, saves you having to kind of memorize every if then, and allows you, I think it's a great resource. So thank you for sharing that, and I'm sure helping put it together. And I don't see any other questions. I see a comment about great information and great job and et cetera. So take the accolades and quit while you're ahead. Thank you very much.
Thanks, Chad.
Thank you very much for this presentation, and really appreciate it.
Absolutely, my pleasure.
One more question.
Oh, did I miss something?
Yep, there was one in there. Someone.
Oh, I see. Sorry. Yeah, can you request agents get tested?
Oh, that's a very good question. In all of the materials that I reviewed to put this together, I did not see anything about requiring agents to get tested. I think particularly, like, let's say there was a report of a positive case of COVID-19 in your office, and you advised agents that they were in the office at the same time as someone who had COVID-19, I think you can encourage and suggest that they get tested, and take that extra step and have, some localities where testing is available to allow them to go and get tested.
Okay. All right, great. And last one was another accolade, more info than I've gotten in many other webinars I've recently attended. So we will again end on a positive note.
All right,
Thank
and
you.
I know it went a little long, but hope it was helpful. And again,
time flies when you're having fun.
Okay.
Thank you.
All right.